SJC-11125, Commonwealth versus Wardsworth.
Good morning, Mr. Shaw.
Good morning. Chief Justice Ganson, may it please the court, my name is Robert Shaw. I'm privileged to appear today on behalf of Demetrius Wardsworth. My intention this morning is to begin with issues surrounding the video evidence testimony, followed by the gang issues, and then I hope to reach the statements of the alleged joint venture and the inaccurate testimony concerning gunshot residue. With respect to the video evidence testimony, this really is a very straightforward issue. We have a surveillance video, which is of very poor quality, and a prosecutor who brought in multiple police witnesses who were clothed in authority and expertise to tell the jury not only what was depicted on the video, but that it matched Wardsworth and Daughtry. And this testimony was really extremely significant in the context of this case because—
Match them and match what they were wearing.
I'm sorry?
Match them and match what they were wearing.
Well, that matched them through what they were wearing.
Right.
It was very significant in the context of this case because we have evidence that the clothing was very common, and not only that, the style and the way it was worn was common. We have descriptions.
Do you have a citation for where we know that the defendant was wearing a sweatshirt with a zipper as opposed to—
I certainly do, Your Honor, and I'll get that to you. It's in the brief.
Okay, good.
No, I actually read, I went through the brief. You give all the citations from the witnesses on the porch saying it was zippered.
Right.
But then when I got to your part where you said that he was wearing, excuse me, I got it backwards, that it was no zipper. But when I got to your brief, I couldn't find a site, and maybe I missed it, but I couldn't find the site to where I could see that he was wearing a non-zippered one, okay?
Right. Actually, it's the other way around. The witnesses both said that it was an old-style patch pocket hoodie. The one he's wearing is clearly not that type of hoodie.
Right, but
and
I couldn't find the
Right,
pin
and I
site.
apologize if the site's not there, but I will get that to you. And in addition to that, you will see that the evidence is clearly they have photographs of what he was wearing, and it does not match that. So in addition to that, in the video, there's a T-shirt. It's probably about 6 inches in length below whatever top the person was wearing. That's different from Mr. Wardsworth. And then we have the police officers who are not only usurping their jury's role, but they're really giving testimony where they're suggesting that they can see things that I don't believe is fair, and I believe that when you analyze that video and look at it closely, you will also see that those details that they're suggesting simply aren't there.
Can I ask?
Did any of the police officers who testified say they knew Mr. Wardsworth?
Some of the police officers may have, whether those who testified about the video, I'm not sure. I don't think so. That there was certainly no special familiarity with Mr. Wardsworth.
There was no suggestion that
Right,
they could
that the
observe
jury had-
something
that's
which
correct.
the jury could not.
And then we have prejudice that is really
Can I ask?
exacerbated.
Sure. I actually watched the video, and then I went and then read your excerpts on the testimony.
Yes.
So the officer, particularly the first officer, who says that it's the exact clothing, right? One of the things you're most bothered by. He's doing it with the jury, right? They're literally, he's testifying, and then they're showing this to the jury each instant. Does that minimize the problem a little bit, because the jury is actually there doing it with the officer? So
I don't think so, Your Honor. And I think that you'll see in the other cases I've cited that, and this is far more egregious than those cases, several of them that resulted in reversal. I think what's important here is this is really an issue of cognitive bias. And I addressed this in detail in my reply brief. I attached the studies of Dr. Dror, who, as you probably know, trained judges in Massachusetts on cognitive bias. Really interesting material where he demonstrates that even with forensic professionals, the way they evaluate and cognize and draw conclusions is affected by the bias and the contextual information they receive. So this really—
Was that issue raised below, cognitive bias?
Cognitive bias was not. But in other words, the Commonwealth is saying, well, the jury had the video and they could compare it for themselves. And that's why that's been raised in the reply brief, to say that this really isn't about having the object. This is about the lenses that one looks through. And when you look through orange lenses, you don't see white snow. It doesn't
Oh,
matter
let me-
how
let-
much you look.
So let me ask you about this, though, because I hear you loud and clear, and it's always concerning when the police officer with no special information about this particular defendant is doing what the jury could do, and they have the imprimatur of being police officers. I totally get that. But what we have here is maybe a little bit different, is that you have the police who are right there looking at the clothes. They were actually at the scene when they're talking to the defendant and the would-be co-defendant. They're looking at the clothes, and now they're going back to the video, and they're not identifying who it is. They're identifying the clothes. So it's very serious. It's very concerning. But do you see the difference that I'm bringing out?
I do see the difference that you're pointing out, Your Honor. On the other hand, I just don't think it matters here. And, you know, I think that it's not reasonable to believe that somehow they have any particular knowledge from 2 years earlier and seeing somebody. Their memory is not going to function that well. The jury had the information before them. The jury could look at it. But these are police officers coming in, giving this extensive testimony, and then we have prejudice that's exacerbated because of the sheer volume of the police testimony. And then we have the closing argument of the prosecutor that's emphasizing repeatedly and heavily not only their assertions, but their alleged intelligence, their specialized training, and the prosecutor is characterizing their assertions as uncontradicted fact, which is very troubling. And I just don't think it's reasonable to think that the jury is not going to be heavily influenced by this.
When you say that the issue of cognitive bias was not raised, am I correct that there were objections to the police testifying to the similarity?
There were two objections. One was when the testimony was being summarized. The other one was when the police were trying to explain away why it would be that the person in the video had much more white T-shirt visible, okay, whereas the photographs of what Wardsworth was wearing was very short. So there were objections in that sense on those two issues.
And so when you say cognitive bias was not raised, I mean, I'm not sure if our case law uses the term cognitive
I
bias,
think-
but isn't that the essence of
I
the prejudice?
I think that's correct, Your Honor, but my point here is not that this is an issue preserved of cognitive bias. It is that the nature of the problem here is cognitive bias, in the sense the nature of the problem is that the jury is being influenced by this excessive testimony from the police officers. And therefore, you can't look at the object and say the jury had the object. It's about the lenses they are looking through. And the lenses they are looking through affects what they see. It affects their cognition, their evaluation, and their conclusions about this evidence.
Can I, back to whether there was an objection. It's my understanding that defense counsel only lodged 2 objections during all of this in regard to the similarities about the T-shirt. Otherwise, this stuff all goes in without objection. Is that right?
Well, again, there were a couple of objections. One is when the prosecutor was, I believe, eliciting testimony and going through all the factors and summarizing it. And the other one concerned them speculating that, well, if someone had a heavy gun in a sweatshirt, it would pull up the back, and he objected to that. So those are the nature of his 2 objections. If, in fact, the court finds that they're not adequate, and I think the court should find they're adequate, but if
But they're objected to just very limited amounts of this stuff, because this goes on for a long, long time.
it does go on for a long, long time, Your Honor, and I can't change the record, and
Well, maybe it is a substantial likelihood of miscarriage of justice. I have no idea, but this is not what we mean by an objection being not just timely, but specific. It's very important that the objection be specific so that the judge has an opportunity to look at it and say, oh, that's a good point. I'm going to change my ruling.
Your Honor, I don't disagree with you. The record is what it is. I can't change it.
And was
And
this, by the way, trial before or after our case, which warned against using witnesses to identify individuals unless they had particularized knowledge that the jury would not have?
Well, there's the Vasher case, okay, which was in 2014, but we have the Austin case, which was in 1995. We have the Pleas case in the appeals court, which was before this. And then you'll see a number of other cases I've cited.
Was
from-
the Austin,
I'm sorry, I just wanted to know, remind me when this was tried?
This was tried in 2009.
Okay, so that was before Vasher. which is 2014.
Right, but we have Austin, which is 1995 with.
But isn't
police.
Austin really about a motion to suppress ID involving a surveillance photo with a bank?
Yes, I think that's right.
I'm not so sure how much you can derive from Austin.
I think the principles are present in that case, Your Honor.
Can we turn to the gang
Yes.
testimony?
So,
I was trying to, I've looked at the record, but I have not done so exhaustively. Best I could tell, his basis for saying that this individual was a member of the gang focused on relying upon Boston police records. Is there more that I missed?
well, there is, Your Honor. If I could begin by indicating that this testimony was really presented in a manner that was extremely unfairly prejudicial. And I'd like to address that first, if you would allow me, and then get to the intertwined issues of the deficient foundation and the inability to confront the evidence. The government presented Detective Sixto Merced, he was an asserted gang expert, to say that Wardsworth was a gang member and that the Boston Police Department can identify gang members and gangs because they're familiar with their activities. And then the prosecutor specifically elicited, well, what kinds of activities do gang members engage in? In other words, what are the kinds of activities that someone like Demetrius Wardsworth engages in? That's what is really being communicated here. And then we have Detective Merced telling the jury that gang members are people who are involved in drug transactions and violence. He told the jury that they sell drugs in schoolyards. They sell drugs in playgrounds. He gave an example of seeing drugs sold at the School Street playground in Boston. He told jurors that gang members engage in, quote, a lot of shootings, unsolved shootings, homicides, stabbings. When the prosecutor asked what types of activities gangs engage in, Merced told the jury, again, that such activities include, quote, shootings, drugs, some prostitution, a lot of homicides and shooting.
Okay, any objection to this?
There were objections throughout the gang testimony, Your Honor. He said gangs hide guns in vehicles. They hide guns in our community spaces. They use innocent people as crash dummies and human holsters to carry illegal weapons.
Let me step you back a little bit, though. I mean, do you quarrel with the notion that gang testimony would be appropriate to indicate that there were gangs who had been involved in retaliatory shootings?
Well, Your Honor, there's no doubt that gang evidence can be used as motive evidence. And to some extent, if there's a close nexus and there's some sort of incident that involved spurred some sort of retaliation, the Commonwealth can get that in.
But is it relevant also to the fact that the house next door was a gang member house?
Sure. I mean, I'm not saying that gang
A mistake,
evidence.
in other words.
Your argument is not that the gang evidence might not be appropriate here. Your argument is that, number one, there's no foundation. There's not really a lot of care on what's personal knowledge, what isn't, but the foundational qualifications is incredibly stale, I think, and then that the information that's being put in is not focused, like the chief's question was, about retaliatory gangs.
I think
well
that-
beyond that.
I think that's right, and that's getting into sort of the other problems.
But isn't
just
it more specific, though? Because there's he presents three types of evidence, this sort of background gang stuff, but then he also goes into a fair amount of detail about the Walnut Street versus the other gang. And then the third thing, which I found sort of maybe the flimsiest, is connecting the defendant to the gang. But the
Right.
second one is pretty important here, right? Because there's a lot of back and forth between these two gangs. And this cop is not just talking about his growing up. He's been on the gang task force for the last 10 years, right?
Right, and I just want to draw a clear distinction again, because I think that the issue of prejudice, regardless of foundation and inability to confront, is so severe in this case that it justifies reversal of the convictions. I mean, this poisoned this proceeding. Now, in terms of this back and forth, incredibly, really, Detective Merced was talking about incidents that went back 5.5 years to 2002. incidents where there is not a shred of proof that Demetrius Wardsworth had any involvement, had any awareness, or anything. And what's really incredible about this is that the Boston Police Department had Demetrius Wardsworth in a gang database as the member of a different gang all the way up until 2007, the whole Worthy gang.
I thought it was an affiliated gang, right, with Walnut Street.
Well, again, I mean, there's no evidence regarding how it could be affiliated, but that was all the way up until 2007. These incidents are going all the way back.
I thought he testified to alliances between the different gangs.
I think in his voir dire, he may have just mentioned in one sentence alliance. But again, you know, that's pretty interesting that this is going 5.5 years earlier. And you've got Detective Merced. And remember, all of this is coming in, all of the prejudicial material, all of this is coming in on direct examination. Under our rules for expert testimony, he is not supposed to go into this detail, certainly not all this prejudicial detail
Well, he can go
on direct
into, he
examination.
can go into the detail on direct that he has personal knowledge of. So if he has personal knowledge of the conflict going on between the gangs, or so-and-so lives here, or I've seen this person in these colors, things like that. If it's personal knowledge, it can come in on direct, and some of it is. The problem is some of it isn't.
Well, I think a lot of it isn't, Your Honor, and I'd have to give some thought to that. I'm not sure, even if it's personal knowledge. Our system for expert testimony really requires that defense counsel have the opportunity to choose whether he wants this sort of detail and data to come in.
No, that's not the case. It's if it's otherwise admissible but not admitted, it can't come out on direct under Nardi, DYS versus a juvenile. But I think your point's well taken, that a lot of what does come out on direct is not something that he can actually testify to on personal knowledge.
Yeah. Now, in terms of the foundation, the issue is intertwined with confrontation because the nature of the foundation made it very hard to, or impossible, I would say, to confront. But we have Detective Merced, and I won't go through all the bases, I don't have time, but his basis of knowledge is grounded in growing up in Boston as a kid 30 to 40 years earlier. This is before.
Can I press you, because, and this is hard. So he's not the person who put him in the gang database.
That's
He
correct.
testifies how the gang database is created, but he says someone else stuck him in.
And he doesn't know who it is.
Right. And he also says he's known the defendant since he was 8 years old, right?
Well, he knows of him. I mean, he didn't provide any detail that says, I know all about his activities and so forth. In fact, his testimony is that Demetrius Wardsworth never admitted to being in a gang. He doesn't have any tattoos. He doesn't have a street name. None of these factors would have indicated that he was a gang member.
Could you walk through the specific instances? The incident with Scott Kelly, there are three, he's aware of three particular, a couple, I may be misremembering, 2 or 3 incidents where the defendant is involved in what he talks about as some gang-related activity. But they
That's
seem
correct.
to, I couldn't follow exactly what they ended up being.
I think it's very important when you go back to the record to look because Judge Neal really pressed. He wanted to know what is the real basis of personal knowledge that he has. And I think it came down to a couple of incidents. One is Mr. Wardsworth was being arrested, I believe, in his home. And he says that he found some drugs in his pocket of his jeans. He considered that gang evidence, okay, because in his view, and in this very exaggerated testimony, drugs are an indication of gang involvement. Then the second incident is he says he believes he viewed a hand-to-hand drug transaction involving Wardsworth and another individual. It turns out that no drugs were found, nobody was charged with selling drugs or receiving drugs, and the other guy was charged with
Kelly
trespassing. That's right.
Okay, it's the Kelly.
And the whole idea here is they're saying, well, we believe that that other guy may have been a gang member, not at the time of this incident, but later on. And when he was pressed on that, it turns out that he's referring to someone in the gang database who has a different name.
Now, I can't remember, has the defendant been shot previously, or is it the co-defendant?
The defendant was shot at, I believe, 7 months earlier.
And
And
what
the
is,
co-defendant too, though, right?
10 days earlier, Dautre had been shot at. I believe.
So he shot, what do we know about the detail of his shooting? I know he says he doesn't identify the shooter.
He says
And so we don't know anything
There-
more than that?
there is no information about it, as I understand it. He didn't know who did it, and there really is not extensive information about it.
Can I, before you leave, ask you about the purported to be joint venture statements? And I have two issues. Number one, on the joint venture, there's going to be an argument from the Commonwealth that the statements of the co-venture are made during the joint venture. And you're going to say that they're made after the joint venture. And then they're also going to argue that since the statements aren't made for, often for the truth, but to say the state of mind of the co-venturer as it relates to the defendant's relevant and their lies, and we have a number of cases that talk about lies not being often for the truth of the matter asserted. So we know we're going to hear those arguments. You're not going to be able to make them while you're sitting down.
Right. Thank you, Your Honor. This was not happening during the pendency of the joint venture. Judge Neal found that. I mean, that was his finding. It also,
If that's the case, then it can't be a joint venture statement.
well, I think what the argument is that the incident was over. I mean, certainly it was 50 minutes later, no emergency at that point.
No, the argument is the cover-up is still going on, and that's
Well,
the
yeah,
joint
and their
venture.
argument is the cover-up is still going on. But of course, there's no evidence here that there is any sort of coordination. In fact, the evidence is the exact opposite. I mean, the evidence is that it's not coordinated, and yet they want to use that as a basis to get this in. And that simply is not permissible. What does that do to the law? It eviscerates our system surrounding this sort of issue, our evidentiary system, our rules. So it certainly is not during the pendency. There's no evidence that there's any sort of common scheme to evade the police. Now, the most typical cases are two joint ventures make statements to one another, and when they make those statements to one another, it comes in. Unbelievably, here we have the alleged joint venture. He's basically in custody. He's talking to law enforcement.
What do you do with the fact that everything is being introduced to show that Doherty is lying rather than telling the truth?
Well, this is a very, I think, interesting and important issue because truth is at issue if the purpose is to say that it's not true. Why does the Commonwealth get to assert, we say it's not true, therefore we get all of these statements to come in? And these statements were pervasive. They show up and were at issue through 6 volumes of transcript in this
Is there
case.
any case that makes that point? Because we tend to have this sort of, and your sister's going to have a list of cases about truth and falsity. So are there any cases that do, I saw your argument, and there's some intuitive appeal to it. Is there any support for it, case support for it?
Well, I certainly think there's support for the fact that if one needs to test credibility, then that triggers the right to confrontation. It can't just say, well, you know, it's not for its truth, and therefore there's no right of confrontation.
That's actually exactly right, though. If the Confrontation Clause protects against hearsay, that nonetheless, within an exception, offends the Confrontation Clause. If one of the first things you'll read in Crawford is if it's not offered for its truth, there's no hearsay problem. There may be all sorts of palpable problems like the undue prejudice if it's used for its truth, but the Confrontation Clause is gone if it's not being offered for its truth.
But, Your Honor, I think you'll see, and I think you'll see in the cases that I cited and specific language in certain cases that really address this issue and say that's really not enough when, given the circumstances at trial, it's being used to implicate and convict the defendant.
Well, then you're either addressing Bruton or you're addressing that undue prejudice of the statements, but it can't be the Confrontation
Well, which I
Clause.
do. But again, the other point that's very important here is that this really is about truth or falsity. The fact that they say, well, it's not true, it's false. Well, who was true? Who was telling the truth and who was telling something that was false? Was it Wardsworth? Was it Daughtry? Why was Daughtry saying what he was saying? What were his motivations? Was he sincere? Was he credible? Why is it that Demetrius Wardsworth doesn't have the opportunity to confront the evidence, probe those issues, influence the evaluation about was it not true? Or was it true?
Does the
Or-
judge have to instruct the jury that it's not being introduced for the truth? Is that part of the judge's instruction?
In this,
If so, was that instruction given here?
I think there was an instruction given saying that it needed to be during the pendency of the joint venture and in furtherance of
They
it.
seem to be, everyone was caught up in trying to understand whether Zanetti changed the I read the joint, I read the back and forth, but they don't, the judge doesn't instruct on the truth point, does he? That it's not being offered for the truth of the matter asserted?
I believe,
Or does he? And I missed it, because it's 21 volumes and it was a late night.
right. I'm not sure, Your Honor. I don't have a recollection of him using that specific
But it
language.
would be hard to believe he's going to say you can consider this for the truth if you find, independent of the statement, that it's during and furtherance of the joint venture that you find exists. And then say, but don't consider it for its truth. That would be strange.
But again, if truth wasn't at issue, if the issue was only that Daughtry was saying something that really wasn't true, why couldn't they just say Daughtry was making statements and generally say that they didn't appear to be true? What really happens here is they're allowing in the content of multiple statements. And they're allowing in a statement where Daughtry is saying, he's actually implicating Wardsworth in the sense that he's saying, well, I was behind a building, I heard shots in the distance, and then not that long after that, I see Wardsworth walking up the street, he's in the gray hoodie, there's another individual who's wearing a black hoodie, which obviously fits the descriptions. I mean, this is content that is implicating Wardsworth.
So then
Why would that be relevant?
Well, it certainly can't be joint venture. It's not in furtherance of the conspiracy if you're trying to.
Well, that's the other problem, and that's the first issue, and that's the reason why we say that none of this should have come in. And given how pervasive it was really highly prejudicial.
If we can separate out the two statements, because there's the statement made immediately after the shooting, and then there's the statement made the day after, where he says he saw him with somebody named D, I believe, correct?
That's correct, Your Honor.
Now, to what extent,
Could I ask,
To what
could
go
I
ahead.
just ask, is that, which day was which statement? Because I thought it was the opposite, and I'm sure I'm wrong, but doesn't he say D on the first time, or?
That's right, Your Honor. So they stop them 50 minutes after, and they separate them, and a statement is made. And I believe at that point, he indicates something about being behind the building.
The chief's question, though, is the statement about D and seeing the defendant walk right after the shots are filed with somebody else wearing a black hoodie is right after they stop him, right?
Well, that's correct, Your Honor. And whether he went into that much detail initially when they stopped him on the street, or whether it was when they brought them down to headquarters that evening, that is really when that occurs. Okay, so there are two statements that go into being behind the building, these two additional people. There's another statement that I would separate out, which is at headquarters that night, when he makes a statement about GSR, where he sort of apparently doesn't want to be tested for GSR, which is the other issue I was hoping to get to. But, and then there are lots of questions about, who knows why that was. Did he really make these statements at all? And then there's a statement in February. I think at that point, what they introduce is the fact of the statement, along with the fact that he didn't want to be tape recorded, which I think is prejudicial. And then they say that he made a statement on the day he was arrested, which by implication isn't very positive either.
the statement he made about hearing shots and then seeing the defendant, your sister and you appear to differ as to whether that was inculpatory or of no consequence?
Right, I know my sister indicates that she believes it was providing an alibi. I believe that when you review the record, it's going to be clear to you that that's not the case. And I think that by reviewing the content of that statement closely, you'll see that this was implicating Mr. Wardsworth. And there's no doubt that Daughtry was really trying to exonerate himself in a sense and implicate Wardsworth. I mean, the larger statements from which these cherry-picked portions came out make that very clear. I mean, I don't think there's any dispute about that. I don't think that the trial prosecutor was disputing that. Now, Your Honor, do you want to hear about the GSR or?
Oh, I think we'll rely upon your brief for that. But
Okay.
before you leave, there's one other question I have. From the video, there appears to be, the area directly in front of the shooting appears to be well lit. Is that borne out by the testimony, or is that simply a product of the way the video was made?
Well, there was a lamp post not too far from the area. Now, on the video, obviously, I mean, the detail is very limited. You can't even see color, and I point that out in my brief. But there was a lamp post that was not too far from the area, and that's probably why these two witnesses indicated that the person in the gray hoodie was wearing an old-style patch pocket hoodie, which again was different. And they're indicating that that person had light skin, and these things don't match. In addition, saying faded blue jeans doesn't match what Wardsworth
They
was wearing.
describe Daughtry?
I'm sorry?
Did they describe Daughtry? Skin tone?
No, I don't believe there was any description of skin
They,
tone. I
they
don't
describe Daughtry's sweatshirt. Was it also a hoodie with or without a zipper?
I believe black was,
But they didn't say whether or not it was a zipper or,
no, they did not.
but can we see that from the pictures?
Oh, from the pictures. Sure, you can see it from the pictures. You certainly can't see it from the video.
Where would we find these pictures? Where in the record appendix?
I don't believe, well, they're exhibits, so they were
We have. access-
introduced at trial. So
Do we have access to them in the record appendix?
I'm not sure, Your Honor. You know, the record is very extensive,
Oh, it
and
is.
much of it's on disk, and I apologize for that. But I'm not sure whether,
Could you check that out, please?
I certainly will.
All right, thanks.
Do we have the sweatshirts? Are those in evidence?
Oh, yes.
The sweatshirts themselves are in evidence.
Sure, I believe they are, yes, and photographs.
Height, how different were they in height?
Not a great difference. I don't think there was a great difference in height. I think
I
that.
think I saw about 2 inches difference. Is it 6 feet versus 5'10"? Was that the difference?
I think it was 6 versus 5'11" in one of the briefs.
Right, something like that. And I think it's very close. And again, I think that just in terms of viewing this from the perspective of the video, we have a very grainy video. We have a camera that's very high, coming down at an angle. And we have two individuals, at least on the video, where their hoods are up. And it's, I mean, to say that one could accurately identify height when two people are wearing hoods, I just don't know how that can reasonably be claimed.
All right, thank you.
Thank you.
Ms. Campbell?
Good morning, and may it please the court. Kaylin Campbell on behalf of the Commonwealth. We ask you today to affirm the conviction of the defendant for the first-degree murder of Uriel Duncan. I think I'll start with the statements issue, if there's no objection to that. And
Here's the statement of the co-defendant.
it's a statement of the co-defendant. I think it's important what was sent when. And so the statement 50 minutes after the murder, and this can be found on volume 5, pages 170 to 171. Daughtry told Sergeant Tiem that he had only been in the area for a short amount of time. He had met up with the defendant 15 minutes earlier, and he had just come from 24 Walnut Park with the defendant, where they were with their boy D, who lived at 24 Walnut Park.
Isn't there another statement where he says he sees the defendant walking, he hears the shots fired and he sees the defendant walking with someone with a hood?
Yes, and that is the statement that's given later on that evening at headquarters, and this can be found on transcript volume 9, pages 234 to 238. That's where there's testimony about that statement. That was the statement that was given to Detective Harris. And specifically, Detective Harris at trial testified that Daughtry told him that he was alone behind 2024 Walnut Park that night smoking a blunt for 10 minutes when he heard gunshots. When he finished his blunt, he walked out to the front of that address, saw the defendant, who's wearing a gray hooded sweatshirt, with their friend D, who was wearing a black hooded sweatshirt.
That inculpatory rather than exculpatory? Because that's basically saying, I saw the other guy where, it's not me, he was with another guy in a black hooded sweatshirt right after the shots are fired. That doesn't seem like part of the joint venture to me. That seems like, it's time to bag my friend.
And I don't read it that way.
Really?
No.
You're pretty smart. Tell me how you don't read it that way.
Because I think due to the timing, it's the 10 minutes with the gunshot. He doesn't say, I think if there's more evidence such as, he was really excited and he got there and he was with this guy and they were amped up, it's just that they're casually standing there. And this is what they happen to be wearing. I don't think that it goes so far as to point the finger.
He makes the point out of saying the other guy's wearing a black sweatshirt, which is the key to the whole case, is that one guy's got a gray sweatshirt with a white T-shirt hanging out, and the other guy's got a black sweatshirt, and then they discovered two guys, one with a gray and white, one with a black. Really, you don't feel that's inculpatory?
I don't think it rises to the level, when you read the Bruton cases, what rises to the level of pointing the finger at the other individual as the person who
Well,
did it.
put the Bruton issue aside, though. What about the issue if it is in fact exculpatory toward the out-of-court declarant and inculpating the defendant, then how is it 90 minutes later during this conversation that the joint venture is still going on?
I think I would point to the Wood case and say that the reason why I think it's still going on is that they're giving lies to cover up involvement in the joint venture. According to the defendant, the next day, the two then meet up and go over the stories that they told the police. And lo and behold, the next time the defendant speaks to the police, which is demonstrating that the joint venture is still ongoing, the next time the defendant speaks to the police, he alters his story to more align with Daughtry's.
Yeah, but this is during that interim period.
I agree, and I think that insofar as they're telling lies about their participation, trying to obfuscate who has responsibility for what and the details of the crime, then that supports that the joint venture is still ongoing. And I don't think that you can find that the judge, I disagree with my brother that the judge found that there wasn't a joint venture, because as to these two statements, he gave a joint venture instruction. So I don't know.
What are the implications then if the joint venture, because maybe the joint venture ended, now they're out for themselves, that's not really a joint venture, and then the joint venture begins again because now they've got an agreement to cover it up, and this is in the interim period, but the evidence under Commonwealth versus Collette is admissible because it's a state of mind of the co-venturer being relevant to the defendant's state of mind. And it's right on all fours with that case, let's say that it is, but just as Kafka points out, there's a joint venture instruction. There's no instruction that's not offered for its truth. How does that play into the concerns?
I don't think that that's fatal. In my reading of cases that talks about hearsay that's otherwise admissible, there's no requirement that a specific hearsay instruction as to
But
that
it's not within a hearsay exception.
Well, it's simply not hearsay,
Right.
correct?
Right, and there's no such instruction.
So the judge doesn't have to instruct that it's not being offered for the truth of the matter asserted?
That's my question.
In cases and the cases that I cite where it talks about hearsay being, a statement being admissible for another purpose, I wasn't able to find anything that would suggest that the lack of this instruction would be fatal.
Yes, so here's the reason for my question.
Sure.
It's hardly fair to fault the defendant for not asking for a limiting instruction that's not offered for its truth. If the judge just told the jury it's offered for the truth, if you find independent of the statement there's a joint venture and it's during and in furtherance. You can hardly say that that's not a preserved objection that we look at as under a substantial likelihood. That's the reason for my question.
But I disagree. At the outset of when they're discussing this, there's a lot of back and forth as to how it would be admissible, and it's never. I'm not quite sure where you have to preserve objections, how that comes into line with that. And I think sort of the prejudicial aspect of it anyway, when you look at how it's used at trial and you look at how the prosecutor uses it in closing argument, it's never used for the truth of the matter asserted. It's never used for the fact that Daughtry was in fact behind this address. And I do want to address sort of my brother's argument about the truth being relative and how do we know what's true and what's a lie. How we know what's true and what's a lie is that the police detailed their investigation to try to corroborate any of the things that Daughtry said. And they were unable to corroborate any of those things that Daughtry said, same as the defendant in this case. It's not as if they just took the statements and I'm up here and the trial prosecutor was up before the jury saying these are lies, these are lies. It's we got these statements, we investigate these statements, they say that they're at this address visiting this apartment number 5, we go and speak to the person in apartment number 5, we find out that they were never there that night, she doesn't know who they are, it was a woman with a young child. Same thing, he says that he's outside, Daughtry says that he's in back of this address smoking a blunt, the officers testified about how they searched that entire area, looking for any evidence that there were blunts being smoked or anything that would corroborate what Daughtry said, and they couldn't find any.
Can I push you a little bit on this? Because, and so the defendant is, Daughtry's lies are helping undermine the defendant's case, right? They're both sort of talking, they both lie about where when they're immediately questioned, they're both saying, no, I was over here and he's saying over there, and it doesn't make a lot of sense. So that starts undermining the credibility of what's going on here, right? All the lying. And then Daughtry kind of provides this very helpful thing for the Commonwealth, which is connecting Wardsworth right to the gunshots, doesn't he? And sort of distancing himself. And then Daughtry's the only one with gunpowder on his hands, and you're
Correct.
all right, and your guy doesn't have it. I don't know. It just seems like it gets messy because they can't cross-examine Daughtry because he's,
Because he
protected.
requested severance in the case.
Right.
And the defendant requested that he be severed in the case.
Right.
But that doesn't open the door to the
It
admission.
doesn't, the reason why they're not together is because of
Right, I understand.
motions that were filed.
Following up on that, you say everything that Daughtry said was a lie. Was his description of where the defendant was consistent with what the police would have said would be where the shooter would have been after the shooting?
No.
How does it differ?
The police, as to, where these two individuals were 15 minutes after the shooting, the police don't know. They know that 50 minutes after the shooting, they're found coming out of the apartment on Walnut Park, but they don't have any conclusive proof or know where exactly they went after the shooting.
But their theory would have been that they were on foot when they did the shooting.
Correct.
I guess one does not know if they had left a car to go there, but if they had been on foot, is it consistent with having run or walked from the Academy Homes area to the Walnut Street area?
That it would take 15 minutes? I think it's, I don't know the answer exactly how far apart. I know from my reviewing of the record and that there were different ways that you could get from Academy Homes to this specific part of Walnut Park. There were multiple different routes that you could take, and that the police certainly investigated looking for surveillance cameras and video to see if they could find out which route which was taken. They could not. So I just don't want to misrepresent anything in the record to say one way or the other whether it's consistent or not consistent.
So I'm trying to think through. So Daughtry lied. Generally, we would say that goes to Daughtry's consciousness of guilt. How does it implicate the defendant without going beyond its evidentiary limits?
I think it implicates the defendant insofar as you have two individuals that are both lying.
But isn't that exactly the problem? Is that you're basically using the deviation in their two stories to implicate this defendant, but the contention is that Daughtry is lying, which generally only goes to his consciousness of guilt and not to the defendant's consciousness of guilt.
But insofar as you want to, no, I don't think that that's problematic, because I think I would be in a different position if you didn't have that next day evidence that the two get together and talk about what their stories are. I think I would be in an entirely different footing, an entirely different position. I think from that, it's reasonable to infer, and it was reasonable to make a finding that the joint venture was ongoing. This joint venture hadn't stopped. And when they speak to the police, they keep furthering the joint venture in that they don't point the fingers at each other. They keep up their lies to conceal what the facts of the crime were, what their participation in the crime was.
But the joint venture provision that says that should be treated as not hearsay is because of the inherent reliability that as long as they're involved together in a venture, they're not going to be lying to each other about it.
Correct.
It's only matters if you're offering it for its truth.
Correct. I think
which you were not.
The problem here is that we were never offering it for the truth.
Although your brother would argue that the statement about him being on the street after the shots were fired would be understood by the jury to be implicating him in the shooting.
Perhaps, but it was never, if you are afraid of that prejudice, when you look at how the prosecutor used this evidence and marshaled this evidence, it was, you shouldn't believe anything that they say because we've proved, through investigation, the evidence doesn't show you that any of this is true.
But it's a no-lose for you, because if he's lying, it's consciousness of guilt. And if he's telling the truth, he's confirming your story that a man with a gray sweatshirt and a white T-shirt and a man with a black hoodie are leaving in that direction after the shots are fired. And furthermore, Daughtry's getting himself out of it by saying it's somebody else. So he's providing a story that confirms what you're trying to prove, at least for the defendant.
And I obviously disagree with that.
No, that's what your job is.
I think so far as, that the Commonwealth didn't rely on that because the Commonwealth believed through all of the evidence that Daughtry was making up this other.
They believed that the defendant was the guy leaving in the shots. They just thought Daughtry's trying to stick somebody else in there rather than himself. But he may be telling the truth about the defendant, but just not about himself.
Yes, but that wasn't what was argued.
Wasn't there some evidence or some reason to think that the police knew that some of this testimony was in fact true?
Whose testimony?
Defendants? At least as to where they had gone right after the...
There was evidence that the police, through the grand jury investigation, so you're asking about apartment number 6 in 76
Yes.
Walnut Park.
And that he didn't want to say he was actually doing a drug deal. Why would he want to say that?
Why wouldn't he want to say that?
Why would he want to say that he was doing a drug deal when he was asked by the police, where were you? Well, I was doing a drug deal. Wouldn't that just sort of implicates him in another crime?
Sure. The Commonwealth never disputed that he was inside 76 Walnut Park.
Oh, they didn't?
No.
I thought you
No.
said that they did.
No, they dispute the lies that the defendant told. He says that he's inside 76 Walnut Park at his Uncle Mike's apartment. We dispute that he was at his Uncle Mike's apartment because there's no evidence that the resident of number 6 was Uncle Mike, was ever known as Uncle Mike.
But that was where the drug deal went down.
That's where the defendant claimed, and the resident of number 6 claims that a drug deal went down, yes.
Okay, so the prosecutor knew that there was another version of that story. It was
And the prosecutor presented that to the grand jury.
to the grand jury. What about at trial?
She didn't present it at trial. I think it would have been objected to and excluded as prejudicial towards the defendant, but she never disputed that the defendant was inside 76 Walnut Park. All she disputed was his story that he...
Mike.
What?
Uncle Mike.
Uncle Mike. And if you look at her closing argument, she says, you heard evidence that there may be some confusion about where he was. Make no mistake about it. What we do know is when the police see him, he's coming out of 76 Walnut Park. That's coupled with evidence that you couldn't get in 76 Walnut Park, and it was one of those locked doors, so a resident actually had to buzz you in or someone had to let you into the apartment building.
Could you talk to us about the gang? Unless, I don't want to cut people off, but the foundation
Sure.
for the defendant is a member of this gang.
Sure. So I think it's important to talk about Detective Merced's specific, what he testified to as his, the foundation for his testimony. And I think it's important to view that in light of the Barbosa case, which I cite in my brief, which is 477 Mass 658, specifically pages 667 to 668. And in Barbosa, this court held that proper basis of foundational basis for this type of expert opinion include facts within the witness's direct personal knowledge or unadmitted but independently admissible evidence. And it says that an expert can formulate an opinion based on use of informant, street sources of information, the school, police, teachers, probation officers, enemies, and where officer had personal familiarity with the victim defendant and their respective gangs. So when you look at all of those things, when you look at Detective Merced's testimony during voir dire, he does establish the proper basis. Specifically, he had firsthand knowledge of the events because he had personally witnessed and heard them, both through growing up specifically in Walnut Park. It's not
30
just
years before?
he had lived in Walnut Park. He testified, and he had been a police officer for 12 years. And
But he lived there, right? And he grew up there, but that was 30 years ago.
sure.
So what?
Well, no, I don't think it was 30 years ago. It was this officer is not that old.
Well, it was a long time ago.
Sure, but he's testifying as to his personal knowledge as to things that happened in the neighborhood when he was growing up.
Why is that relevant?
It's relevant because this is a ongoing feud between Academy Homes and Walnut Park, and it's just testifying his deep familiarity with the area. And saying that he grew up there, he's saying he personally knew who the defendant was and who all of these players were and what this violence was because he witnessed some of it firsthand. But I think
But the stuff about the defendant, I get that he knows about this gang warfare between these two gangs. But,
Sure.
From the combination of the fact that he's in this gang task force, that's responsible for this area, right?
Yes, for 10 years he had patrolled this
In
specific
the
area.
past 10 years, or what 10 years are we talking about?
He had only been a police officer for 12 years. So for 10 of those 12 years, he was assigned to the Walnut Park area. And for 2 of the years, he had been on the youth violence strike force.
So I get that part, but then, and he knows the defendant, I understand that, but when I actually look at the basis for the defendant being in the gang, he describes the fact that a different officer stuck his name in.
Yes, and I disagree with my brother's assertion that that officer was not known on cross-examination during the voir dire.
Gave a name for it.
Vance Mills, correct.
Yeah, I got that part. But, and then he testifies how you get in the gang database, but it's not a science to that.
Correct.
And then he describes the incidents involving the defendant, and there's not much, given that the guy knows the defendant, he's been in this task force, right? Tell me
Sure.
what do we, why should we say, okay, this is reliable, that this guy's in the gang? Tell us that, because that's the part I found the most difficult here.
Okay. I think it's specifically, it's the conclusion of this officer that though sitting on a bench here, it may not appear as gang-related activity, to this officer who had extensive training, who had
Try us out. We've read a lot of these, so.
Sure. And so specifically, transcript 2, page 159, that the defendant was found with crack cocaine. Detective Merced said that he was aware of it in a police report.
Found in his home with crack, he's in his underwear, and they find crack cocaine in his pants, right?
Sure, yeah.
He's not on the street dealing at that point, right?
No,
he's
but
a user, okay.
there's no evidence that he's a user. And it was,
So I don't know what we can derive from this, but go ahead. That's one incident.
sure, that's one incident.
Means he's in a gang as opposed to he's.
No, because they didn't
involved.
classify him at that point that he was in a gang. When asked the specific basis, he points to that and says that's one factor which we base it on.
Let's keep going.
The next one is volume 2, page 160, that the defendant was involved in a drug transaction and
This with Mr. Kelly, who gets acquitted, and it's the trespass conviction? Scott Kelly?
Sure, I'm not 100% certain of that, but this is one where Detective Merced personally responded to it.
But then the guy's acquitted and the defendant isn't found with drugs in that incident, right?
I don't believe so, no.
Okay, so that one's not so good either. Go ahead.
Well, no, I don't believe so. Just because someone ends up being acquitted at trial, there's a difference between
I understand
gathering this
that,
gang.
But being in a minor drug transaction that the person gets acquitted on. But go ahead, what else do we got?
Sure. Specifically then on Volume 2, pages 168 to 169, that the defendant was shot at, and he was shot at close in time to when there was a academy, someone from, so the day before the defendant shot at someone named De La Cruz was murdered. Actually, no, the day before, so February 8th, 2007, De La Cruz, who's a member of one of the gangs, was murdered by someone from Academy Homes. So De La Cruz, who's a member of Walnut Park, is murdered by someone from Academy Homes. The very next day, February 9th, 2007, the defendant is shot at as he's in Walnut Park.
Can I ask about, because I have this vague recollection that, is the officer asked whether he knows of any relationship between De La Cruz and the defendant? He says he doesn't, right?
Correct.
So there's not, it's not like we know that, yeah, but okay.
Sure, but that supports that, the day before someone from Walnut Park is murdered, then Academy Homes goes looking for
I get it,
retaliation.
get shots at,
And then,
But we also know that people shoot the wrong people all the time.
sure, and
That
I'd
probably
say
occurred here.
in this instant, in this specific murder, absolutely, absolutely. And this is Volume 2, page 171 to 172, 10 days before this murder on September 10th, 2007, Detective Merced personally responded to a call for shots fired on Walnut Park. These are the shots that are fired at Daughtry, and he had specific information that the defendant was there at the time that the shots were fired.
Okay, so tell me more about that. So 10 days before Daughtry is shot at, and the defendant is present at that shooting?
Yes, it says, Detective Merced testified that he got info from street informants that the defendant was in the area when the shots were fired, and the defendant's own mother put him there at the time of the shooting.
What does in the area mean?
I have to check.
Is this the shooting that occurs right near his home?
Such a nice man.
This is the shooting of Daughtry. It's on Walnut Park.
But it's right near the defendant's home, right?
Off the top of my head, I don't remember where the defendant's home was in relation to this. But I'd say the presence, the timing of the shooting, the fact that he's there when Daughtry gets shot, along with the other incidents, and through Detective Merced's extensive experience, both personally and as a member of the Youth Violence Strike Force, that he testified it was not only the criteria that the BRIC used to classify him as the gang member. He went over the same type of information, and he came to the same conclusion that the defendant was a gang member
So
as well.
let's assume, based on that, everything you just told Justice Kafka, that not only is he qualified as an expert, but the gatekeeper reliability is satisfied on the methodology and he can testify.
Sure.
Just assume that. Many of the things or a number of the things that you listed were not based on personal knowledge. Now, for instance, he might have found out about the drug deal or learned about the drugs or responded to a shooting,
Sure.
but it came out on direct, as opposed to where under DYS versus a juvenile, that foundation really shouldn't have come out on direct. What about that? I mean, some of it can, what he actually observed can come out on direct.
Absolutely, absolutely. And I think the critical pieces, the critical pieces of it and the critical pieces that were used by the Commonwealth in closing were the parts that he actually responded to and observed in the information that he got.
Of these three instances, which ones had he been personally at?
Sure. The
Cocaine found in the underwear?
No, he wasn't personally at that. He was
Okay,
aware
how
of that
about in the
from-
drug transaction?
He was the drug transaction. He personally was responding to that.
He responded to that one?
Correct.
Okay.
As to the timing of the
That the defendant had been shot at months before, was he present at any of that stuff?
yes,
What
and
was he present at?
he was He responded to the call and was present at Walnut Park.
Okay, and then Dela Cruz was murdered the day before. Was he present at that?
He was not present at that, but he was asked to review surveillance video of the footage, and he was the one that actually identified De La Cruz as the shooter in the video, so he was personally involved with the investigation as to
The
that murder.
investigation. How about when being present when the co-defendant was shot, co-victim, co-venturer was shot 10 days before, when Daughtry was shot?
Yes, he was involved in that as well, and he was told information about the defendant in relation to that shooting from street sources.
Okay.
You said he confirmed the methodology. Did I understand you on that? That the other officer puts the defendant in the database, but you said something to the effect that he agreed with how they did it or something like that?
Correct.
Where is that?
Let me just, I want to double check my site as to that.
It's not easily, we can
I
find
cite it in my brief, but I believe that, actually, it's volume 2, pages 153 to 154, and he says, and the pages before that, 151 to 152, talks about BPD and the BRIC classifying someone, and he says that he uses the same sources of information as the BRIC to come to the conclusion that activity was gang-related. He then goes through the entirety of those sources of information.
Now, is Barboza your best case?
I believe so.
Because in Barboza, the witness was familiar with the defendant, whom he had observed wearing Woodward Avenue gang colors and in the presence of Woodward Avenue gang leaders on multiple occasions. It was personal observations of him wearing gang colors and hanging out with gang leaders. It's much stronger than what you've got.
It is. Do I think it's necessary? No. I think when you look at, Barboza and the cases cited by Barboza, this type of testimony definitely fits in. I also think it's important, too, that there was no objection lodged to the Academy Holmes expert, either through a voir dire or his testimony at trial. And although he doesn't go into the same detail, he testifies to many of the same things.
Who was that?
Detective Brian Smigel, I can't say the last name, Smoglaski.
Okay, so he was an Academy Holmes expert?
Correct.
And what is the relevance of the fact that gangs are involved in many other things other than retaliatory shootings? I mean, I understand the theory that you have a gang war and there's
Correct.
retaliatory shootings, but your brother mentions all the other stuff about selling drugs to kids on the street and all the other stuff. How is that
Sure,
relevant
and
here?
as I stand here before, I don't remember that testimony to the degree that my brother represented to you. I don't remember. First of all, I don't remember it, and I'm not saying that it's not there. It's just right now I don't have a clear memory of that. I don't remember him attacking that in his brief, and I don't remember there being an objection to that. So insofar as that is, I don't want to misrepresent anything.
And you're very good at not doing that, so we appreciate that.
But there was extensive curative instructions from the judges to the use of this evidence, and the prosecutor certainly didn't mention any of that in her closing argument. She focused on the specific incidents, the specific feud, and how this really was the motivation in this case, as known gang members lived right next door to where this victim was seated.
Can we turn to the identifications of the clothing by the officers in the video?
Absolutely. I really think that there is a distinction to be made from the cases my brother cites and what happened here. Insofar as in all of those cases, there's an officer specifically opining that is the person who committed this crime. In a case like this, where the investigation unfolded the way that it did and where their investigation was specifically attacked, it is absolutely appropriate for the officers to explain the reasons why they came to the conclusion that the defendant matched the person in the surveillance video. Specifically, and I'd say—
But you were sort of offering it, at least in theory, to demonstrate the adequacy of the investigation, but doesn't your brother have a point that it would be understood by the jury differently than that? Doesn't it invite the risk that very smart people looked at this very carefully and they saw things which we think the jury should also see?
And I don't understand what would be wrong with that. I think all of the evidence that the Commonwealth produces is we are putting forth this evidence that we believe that the person anytime there's a surveillance video of this crime, I don't think it would shock the jury to know that the Commonwealth and the officers believe that the person sitting at the table is the person in that
Should the police officer
video.
testify to that?
Ab-
Vasher says no, doesn't it?
Thatcher says, no, they can't say, yeah, it's my opinion that that is the defendant.
Is that essentially what happened here?
No, I believe when you look at it, what they do is here are the characteristics that we see in the video that led us to arrest the defendant, that led us to stop this defendant. I don't think the facts of this case can be divorced from how this evidence was presented and what the defense was. And I don't understand a scenario in which you have an instance where there's a description as a gray hooded sweatshirt and a black hooded sweatshirt. You have Sergeant Detective Tian who sees these two people, talks to them, then goes and watches the surveillance video. I don't understand how it's not appropriate for him to say, I watched their surveillance video and I saw that these two people were dressed similarly.
You gotta distinguish those cases from this situation, because if you have a police officer and the police officer is looking at bank surveillance, and they weren't there during the bank robbery, and they look and they say, oh, yeah, that's John Smith, who happens to be at the table that says Mr. Defendant. Here, what you have is, it's light-colored sneakers. He was right there, the police officer's right there, and saying, yeah, I think those are light-colored sneakers.
Well, it's not just that. There's light color sneakers. In the surveillance video, you can see a line, right? So I see the line of the white colored sneakers.
I understand,
and defendant is wearing, pointing to the jury, yeah, look at his sneakers. He's wearing light colored sneakers.
Right, so it's not necessarily analogous to the cases where the jury is in the same position as the witness who's making a comment about the video.
Correct. Absolutely.
And doesn't he go further? I mean, there's, some of it seems fine, but again, I'm reading from 5193. Again, I mean, even the first time I saw it, it was readily apparent that the clothing descriptions of the individuals I had stopped and the clothing descriptions within the video were almost looked exact to me. That's exact is exacting, right? That's tough.
It is exacting, but he's explaining why the two people that he stopped on the street that are dressed in his clothing, why they decided to take them back to headquarters and do these tests and seize the clothing and do the entire investigation. When the argument and when the Commonwealth is tasked with defending against, you looked at the wrong guy, you came to the wrong conclusion, it's absolutely appropriate for the investigating officers to explain the reason why they came to the conclusion that they did.
And did this all get offered after Bowden was clearly part of the defense?
Sure, in opening statement, it was clearly part of the defense.
So you look at this level of precision is necessary to rebut the Bowden argument.
Absolutely. That's not to say that it wouldn't be appropriate in a case where it isn't a Bowden argument either, but I think in this case, given the specific defense that was presented and the specific way that the investigation in this case unfolded, it absolutely was necessary to rebut that defense.
The zipper.
Yes.
Zipper was in the front?
The zipper was in the front. It's not... I'd say that the picture speaks for itself. The witnesses didn't give the description as to zipper, non-zipper until they're interviewed at headquarters after the fact.
And they said there was no zipper.
I wrote it down. Yes, they said it was no zipper. At least one of the witnesses, Roxanne Duncan, and this is on volume 3, page 177.
Gray sweatshirt, right?
There are two of them, right? There's 441 and 3177. No zip. No, two different witnesses say there's no zipper.
Correct. They describe it as a patch pocket style. I don't think that that's necessarily fatal given the distance away that this individual was and the fact that they were being shot at when they saw the individual. It's also, if you look at the sweatshirt, it's not as if there aren't pockets. There are pockets that appear very similar to a patch pocket. There's just a zipper in the middle of it.
What's a patch pocket? I'm not sure I understand what that is.
So a hooded sweatshirt that doesn't have a zipper and then it just has one pocket that's
I see.
connected
I got you.
that way, like
It's
a
the
pouch.
big
Does
It's
zipper
the-
sweatshirt have pockets?
Yes.
It's the Bill Belichick sweatshirt.
It's the Bill Belichick's, yeah, absolutely. But yes, if you look at the photograph, If you look
Was
at
it
the.
Bill's?
Yeah, no, I don't believe it was Bill's. If you look at the photograph, you can see the pockets and how they appear. I looked at the record appendix of both my brother and I. The photographs do not appear in those record appendices. I cite the specific exhibits in my briefing. I'd be happy to move to send them to the court, but they are with the Superior Court, as well as all of the physical evidence itself, the sweatshirts itself, the sneakers, the photographs.
And in closing argument, how did the prosecutor make use of the officer's testimony? Did she use it in a Bowden way, or did she use it in a verifying way?
When she spoke of the officers and their observations as to these similarities, she said, they told you about their investigation and here's what they saw. But she also uses it in argument, as she was entitled to do, which is look at the similarities between what this person is wearing and the surveillance video. It's used in both ways.
Can I ask you whether the witnesses who said there was no zipper, did they say it independently of each other?
They did. They were both asked, they did.
Because they had a rather detailed description of clothing, even of the type of sneakers and...
One of the witnesses did, yes. As to Daughtry, it was less specific. One of the witnesses as to this specific defendant did give very detailed, specifically because she had the same sneakers as the defendant, so it's something that stuck out in her mind.
What about skin tone?
I don't believe that there was testimony about skin tone, that there was the information given about skin tone. I can't totally remember right now, but nothing very, very specific.
And height?
The height came from Sergeant Tian, who was looking at the surveillance video and says that one appeared slightly taller than the other, which is in line with...
Isn't that awful tough to do when you've got a hood? Don't quite know how much further the hood is above your head.
Sure, I would say that if you're looking at the differential between two individuals with their hoods up, and then you have two individuals, and the booking photos, they have them put their hoods up, that it was possible to make that sort of comparison.
Okay,
If there are no further questions, the Commonwealth will rest on its brief.
thank you.